Yes. Okay. Good. Hi, guys. We have Bocce Gohawks here and Carol with Docket Updates. We are reading this full settlement. It's 17 pages. And we can't, we're shocked right now.
I mean, when I got the message on my TikTok, I think it was Kathy that may have sent it to, I don't want to misattribute who sent it to me saying, "Can you read this? It's the settlement." And I'm shook at because usually we don't get to see settlements. But because they have they have the right to do this because there's no NDA, there's no confidentiality thing. I cannot believe this though. So am I eating this up? Am I is super excited about this? Yes. So I was like, okay, I better take my lunch early. It's 17 pages. Let me try to bust through it. But then Carol's like, "You want to go live?" And I was like, okay. So I'm gonna try to read this for y'all's.
Okay.
All right. So settlement agreement and general release. The settlement agreement and general release is made and entered into by and between Blake Lively on the one hand and Wayfarer Studios LLC, It Ends With Us Movie LLC, Justin Baldoni, Jamie Heath, Steve Sarwitz, Melissa Nathan, the agency group PR LLC, Jennifer Abel. On the other hand, Lively and the Wayfarer parties shall herein after collectively referred to as the parties. Oh, by the way, Carol, feel free to stop me by just speaking whenever you have a thought.
No.
Because I'm zooming in on it so I can read it.
I'll raise my hand so that you can see me.
Oh, well, I can't see you because I'm zoomed in.
You're zoomed in all the way? Okay. All right, I'll say it.
Okay,
I'm going to see in the meantime if I can make this just a little bit bigger for everyone, okay?
Okay.
No, I won't mess with this slide, though. Okay.
Okay, thanks. All right, so recitals. Whereas Lively provided acting and other services to Wayfarer and It Ends With Us movie in connection with the film It Ends With Us. Interesting, they said in other services.
You'll see why a little further down.
I'm glad you read it already. Whereas on December 20, 2024, Lively filed a complaint with the California Civil Rights Department against Wayfarer, Baldoni, Heath, Sarwitz, Nathan, Tag PR, Able, RWI Communications LLC, Jed Wallace, and Street Relations Inc., together with Jed Wallace, the Wallace parties, which Lively amended on December 30, 2024 to add It Ends With Us movie. The CRD closed the complaint and issued an immediate right to sue notice. Whereas on December 24, 2024, Stephanie Jones and Jones Works LLC filed a complaint against Able, Nathan, Baldoni, Wayfarer, and Doe's 1 to 10 in the Supreme Court of the State of New York, County of New York, index number 659849/2024. The complaint was removed to the United States District Court for the Southern District of New York on or about January 27, 2025, and is pending in the matter entitled Jones versus Able case, number 25-CV-00779. Whereas on December 31, 2024, Lively filed a complaint for damages in SDNY asserting claims against the Wayfarer parties and the Wallace parties in the matter entitled Blake Lively versus Wayfarer Studios LLC et al. Case number 1:24-CV-10049-LJL, which Lively amended on February 18, 2025 and July 30, 2025. Lively has asserted causes of action for sexual harassment in violation of Title 7, 42 USC, retaliation in violation of Title 7, sexual harassment in violation of FEHA, California Code, retaliation in violation of FEHA, California Code, retaliation in violation of the California Labor Code, failure to investigate, prevent, and or remedy harassment in violation of FEHA, aiding and abetting harassment and retaliation in violation of the FEHA, breach of contract, actor loan-out agreement, breach of contract, contract writer agreement, intentional infliction of emotional distress, negligent infliction of emotional distress, false light invasion of privacy, California Constitution, sexual harassment in violation of California Civil Code, and then defamation per se, and civil conspiracy. Whereas on December 31, 2024, Wayfarer, Baldoni, Heath, Sarwitz, Nathan, TAG PR, Able, RWA, and the Wallace parties filed a complaint against the New York Times Company in the Superior Court of California, County of Los Angeles, case number 24STCV 34662, which they later dismissed. Whereas on January 16, 2025, the Wayfarer parties filed a complaint in SDNY asserting claims against Lively, Ryan Reynolds, Leslie Sloan, and Vision PR Inc., together with Leslie Sloan, the Sloan parties, in the matter entitled Wayfarer Studios LLC et al. Versus Blake Lively, which the Wayfarer parties amended on January 31, 2025 to add the Times as a defendant. The Wayfarer parties asserted causes of action for civil extortion, defamation, false light invasion of privacy, California Constitution, breach of implied covenant of good faith and fair dealing, intentional interference with contractual relations, intentional interference with prospective economic advantage, negligent interference with prospective economic advantage, promissory fraud, and breach of implied in fact contract. Whereas on January 30, 2025, the court consolidated the Lively SDNY complaint and Wayfarer SDNY complaint into a single action, which shall hereinafter be referred to as the consolidated action. The court also deemed related the Jones Works action. Whereas on February 4, 2025, the Wallace parties filed a complaint for declaratory judgment and defamation in the United District Court for the Western District of Texas in the matter. Can I say just how many lawsuits?
Yeah.
Oh my word. Okay.
And for everyone following along, this is just kind of like a recap of what's out there, right?
Oh yeah. I'm like, dang, there's so many out there. Just going through all the actions that were happening. Okay, so sorry. Whereas on January 30, am I in the right part? Yeah. Whereas on January 30, 2025, the court consolidated the Lively SDNY complaint and the Wayfarer SDNY complaint into a single action, which shall hereinafter be referred to as the consolidated action. The court also deemed related the Jones Works action. Whereas on February 4, 2025, the Wallace parties filed a complaint for declaratory judgment and defamation in the United District Court for the Western District of Texas in the matter entitled Jed Wallace et al. Versus Blake Lively, which the Wallace parties amended on May 16, 2025. The court granted Lively's motion to dismiss the Wallace, Texas complaint on November 12, 2025. And Lively has since filed in the action a motion for attorney's fees, treble damage as punitive damages under California Civil Code Section 47.1 against the Wallace parties, which is not fully briefed and is still pending. Whereas the Sloan parties, the Times, Reynolds, and Lively moved to dismiss the Wayfarer SDNY complaint in its entirety on February 25, 2025, February 28, 2025, March 18, 2025, and March 20, 2025, respectively. Lively's misspelled, but okay.
When you go to the next one, because I'm still trying to crop it so that we can see it a lot closer.
Okay, so say that again.
When you're ready for me to turn the page, let me know, because I'm still cropping the pages so we can see it a little closer.
Gotcha. Sorry, I got really lost in the fact that they misspelled Lively, but
call it out.
The court granted each of those motions on the merits on June 9, 2025, thereby dismissing the Wayfarer SDNY complaint. Whereas on March 20, 2025, Able filed a cross-claim for indemnification against Jones Works in the consolidated action. Whereas on September 8, 2025, Lively filed a motion for attorney's fees, treble damages, and punitive damages under California Civil Code Section 47.1, which has been fully briefed and is still pending before the court. Okay, that was before. Okay, then if you could turn the page.
Okay, I'm almost done, so
Awesome.
I'll bring the bigger one in a second.
Okay, coolio. Whereas the Wallace parties moved to dismiss all causes of actions asserted against them in the Lively SDNY complaint on March 19, 2025, and August 13, 2025, which the court granted on jurisdictional grounds on November 5, 2025. Whereas on November 13, 2025, the Wayfarer parties filed a motion for summary judgment of the Lively SDNY complaint, in which the court granted in part and denied in part his favorite thing to do on April 2, 2026. such that Lively's following causes of action remain: retaliation and violation of FIHA against Wayfarer and It Ends With Us movie, breach of contract against It Ends With Us movie, and aiding and abetting retaliation in violation of FIHA against Tag PR. Whereas on May 2 to 3, 2026, the parties, through their legal counsel, attended a private mediation with Tony Piazza, through which the parties have decided to settle fully and finally. Really?
Mm.
I hope so. Settle fully and finally all differences and disputes between them up to and including the date the parties signed this agreement, including but not limited to those differences and disputes which are or were the subject matter of the consolidated action, and any and all claims which could have been alleged by Lively or the Wayfarer parties, with with the exception of Lively's pending 47.1 motion, as further detailed below. Whereas on May 4, 2026, following the mediation, the parties signed a confidential and binding memorandum of understanding memorializing the parties' agreement to resolve the disputes between them and agreeing to subsequently enter into this long-form agreement, which will incorporate by reference and supersede the MOU upon mutual execution by the parties. I mean, do you trust a person who didn't sign her contract? Anyways, now, therefore, in order to resolve all pending and potential claims by the Lively on the one hand and the Wayfarer parties on the other hand, arising out of or related in any manner to the film, the CRD complaint, and the consolidated action, and in consideration of the covenants and promises contained in this agreement, the parties agree as follows. The agreement is resolution of the consolidated action. In consideration for the execution of this agreement and the mutual release of claims set forth, and the parties' full and complete compliance with all covenants and promises herein, the parties agree as follows. A, the parties have already agreed to and have already released a mutual statement regarding this agreement, which was a pointless thing to do. Like, why did you even bother? Because y'all backtracked on that so quick, both sides. Anyways, which is attached as Exhibit A here too.
I wouldn't say both sides. I would say Gottlieb definitely did not honor that when he said that they won. I don't think that Wayfarer claimed victory. They were just like, it's over.
Well, I think at the end though, like both said stuff. I don't know who said first. I thought it was Gottlieb, but then somebody said no, it was Friedman. I have no idea. But all I know is at some point I defended the joint statement. I was like, I get it. They have to say stuff like that. Mm-hmm. It's a joint statement, because I was assuming neither side was going to say anything. But then next thing I know, these headlines of, winning, blah, blah, blah. I was like, ugh. Why even do a joint statement at that point? It's such a contentious case that is a pointless, it's almost symbolic, not symbolic, but what's the purpose, right?
Yeah. It's a continuation of what we've seen.
Yeah, it's just, I mean, this is Blake Lively. You cannot trust this person. The parties agree that notwithstanding anything herein to the contrary, Lively does not release and retains all claims, rights, and remedies. Oh, I hear what the carve out you're talking about.
Mm-hmm.
I hear the carve out.
Yep.
It's
now, let me switch the document. Can you see that a little better?
Yes. Yeah, I don't have to actually zoom in now.
Okay, good.
Oh, I see it now. So, but you actually went somewhere else.
Oh no, that's where it continues. So rights and remedies, and then the page. You said the way. Oh, did you not finish reading the other one?
No. I haven't.
Okay, I don't have that page because I thought you read it. Hold on.
I was like, no,
not yet. Okay, sorry.
Because I thought that Brian Friedman didn't say anything about it.
There it goes. Sorry.
I agree with you. I thought he didn't, but then people were like, no, he was the one who said it first. And I was like, was he?
I saw all 3 interviews he gave. So he gave Donna, Zach, there's like 2 more that he gave that day, and he said, "We're happy that this has ended. This is like very happy news for my client." I didn't hear any words of victory. I could
Well, I think people read into that and they wrote articles where it says, "Oh, they're." I mean, because why would you be happy with a loss? I mean, or something that where you didn't benefit from it. You know what I mean?
I
I
think
mean,
that's, in my opinion, I think that that's very different than what Mike Gottlieb said.
this
We
is
have
true.
a resounding victory.
Yeah.
You know,
Roll
that's
my
different than,
roll
hey,
my
we're
eyes.
happy. It came to an end. Okay,
Yeah.
guys, just for the people just joining, this is the full settlement agreement. Megan Kelly shared it on her website. And she went and covered it. I'll add the link in the description, but that's what we're reading.
But you know what? Okay. This is why it sucks, because Blake is so much technically true, contextually, like,
Yes.
but so I hear the carve out that you're thinking, I think, when she says, and retains all claims, rights, and remedies. But it says, but here's the thing, but it says relating to her pending 47.1 motion. It's relating only to her pending.
I think so too.
Motion.
Like when you read the last sentence, but this is Blake Lively, right? They've done very sus things. Their ethical like lines are very much crossed. You know, so can they find a way out of this where they're like, let's give her something else, you know, to push? Because I think that everyone's expecting now that they said, oh, well, the judge said that we used the wrong vehicle. We're going to go find the right vehicle.
Mm-hmm.
You know, that statement. Mm-hmm. I think either they're just creating the rumor so that it could be like, oh, Blake Lively's still fighting, but then nothing's going to come of it, or is it really something? So I think that that's why we're reading this settlement agreement. Is there truly a carve out to this?
I mean, and again, with Brian Friedman's quotes, it seems like he doesn't think there is. However, that doesn't mean anything necessarily, because like you said, I just do not trust Blake Lively as far as I can throw her. And I am a weak person.
There's a sentence in there that makes me think like, oh, it does seem very final, but then again, I just think that they need to think like Lively. Like, how can I get out of this? How can I? And then when I look at it that way, it just makes me a little bit like, is it really final? Can she find a way out of this? Like, we can't have this technically true way. It needs to be.
Yeah.
Like, they need to clock around this agreement and make sure there are no air gaps, no anything to let her out.
No, I do think that relating to her pending 47.1 motion locks her into it, only meaning that. It's kind of like when Wayfarer said, hey, we're willing to give hey Elsie, we're willing to give just a section.
I didn't. You put me up fast. You don't announce nothing.
No.
Dang, girl. What if I was naked? You don't give a heads up or nothing. Hi, guys.
But but what was it? Oh, what was it that I was thinking about? With the whole I forgot.
Well, so you were saying,
sorry, I took you out of your flow. That's why you announce people. You don't shove me in there. Now it's my fault.
Oh, no, not your fault at all. I'm just very forgetful.
No, the chat is gonna be like, oh my God, Elsie came in there and she took all that. It's not my fault they didn't announce me like the queen I am.
No, it's my fault that I stopped my thought because you came in and I just wanted to say hi.
Blame Carol. No, Carol should have been like, and coming in at 5 feet tall, Elstrich, and then I would have been like,
I blame Ryan. No,
wait, do we need to do a playback? Should I go on YouTube and listen to what you were saying last before I came in here?
No. Someone said, did you mean the stipulation, Bocce? Is that what you were talking about? The stipulation that there was, that they were going to accept the SH as
yes, thank you who got that right.
As it is EC male. Oh, ISIS. I is that right? Did I read that right? Sorry.
This is why you announce people.
But yes, it's the stipulation. That's what I was thinking about.
Okay. Can you say that thought again?
Wayfarer made But I hear you too, though, Carol, because the stipulation was only for that particular thing. And what did Gottlieb try to do in the hearing? He tried to extend that stipulation. And what did the judge say?
And that's what they keep trying to do. They keep the lively attorneys are just like her, and they're trying to extend past what that allows them. You know, like they try to extend the bounds of what the judge could do and say, hey, judge, if you say it's right, you can do it. You can rule from the bench right now without a trial. If you think, you know, what did they say? The court is not bound by, has discretion of the court or whatever it's called. So they kept trying to do this, and they keep trying to do a switch up. And I think that Wayfair needs to start thinking like them and saying everything we say is going to be twisted. Like, how do we leave no room for nothing? Okay.
But can I say though, can you guys hear me good?
Yes.
Mm-hmm. I've told you, Carol, in our last video, and I realized my audio might have sounded good for you, Carol, but it was horrible for everybody else. But remember, I was telling you about the stipulation. I was like, I hate that, even though it was only meant to survive for trial, because remember, the stipulation was only for trial purposes, it's still going to linger. Like, they're still going to use it as a reason. For example, this entire 47.1 thing, you cannot, especially when we're looking at malice, you cannot say she had malice, but then say, oh, I believe that you believe what happened, and that's why you started this lawsuit, which is what they gave her in the stipulation. Pretty much, they gave her the benefit of the doubt by saying, we don't think you're a bad person and you try to bring us down. We truly believe that you believe what happened. Therefore, you take malice away automatically, almost. You take that away from, the public and everybody else. So I think that stipulation, I mean, in the moment, it didn't look like it was going to hurt if we had gone to trial. Which now I'm thinking they always knew they didn't want to go to trial. And they might have pulled an okie doke on them, acting like the stipulation was, remember when the stipulation came out and they came back and acted like it was going to hurt them? I think the stipulation might have been a reason why they decided to settle.
Oh, yeah. Oh, I definitely have.
The settlement didn't come till after the stipulation. And now, even though they technically shouldn't even mention the stipulation outside of trial, they have multiple times tried to use it as a reason for things. And I think it's helping them more than it was going to help the Wayfair parties had trial commenced. So I will always hate that stipulation.
I will say, I just want the Wayfair parties and their PR to understand that is exactly what's going to happen each time. Like, if we're already we already foresee it, like, they need to start foreseeing it and spell it out. You cannot use this statement for blah, 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 blah. You cannot use, like, the other party understands that this cannot be used, and put that into the agreement and put that in writing.
I mean, it is. That's the thing. It was in writing. It was agreed upon. This is for trial purposes only. But the funny thing is, I mean, a lot of you guys, let us know in the chat. Do you remember that? Do you remember the stipulation only being for trial purposes? Or once you heard that in your head, that Wayfair believes Blake had the right to sue, you forgot about all her bad intentions. You just went with the flow of, oh, she didn't have any bad intentions. She truly believed everything that happened. Why are you laughing, Bocce?
No, I was like, no, I didn't.
No, in the moment, I'm telling you, nobody thought it was only for trial, but who would have thought, oh, once we don't go to trial, we would never hear of the stipulation again. And I think
that's why they need to start thinking that way.
And maybe they should have put it in a settlement.
It's going to be used this way. Yeah. It cannot be used for blah, blah, blah. And just start, like, I think just start thinking that they do not have some ethical bounds that we're all operating under.
But I think this is a classic. You cannot put the toothpaste back in the tube. Like a jury cannot unhear. Yeah, we could be at a trial and a judge can say, jury should disregard that. If I say, oh, I did it, the judge is like, actually, disregard that. The jury heard me say that. So it's like if all of us are the jury right now, and we heard Wayfair come out and say, we're going to stipulate that Blake believed what happened, and that's why she started this lawsuit. Fine, we don't go to trial anymore. Fine, there's a settlement, but you cannot make us forget that you said, fine, you believe her. And now if she tries to say there was no malice ever, you actually told me you believe me. Nobody's going to remember.
I think I'm not that type of person to make those kind of conclusions.
Yeah, but me and you, Carol, me and you and everybody else who reads these documents, we're not making those assumptions. Everybody else, even our people who listen to us and follow us, who are consuming this on a, like, a quick basis day to day, they don't have time to read everything. We try to give them as much information as we can, but they still are only hearing, the highlights of it.
Headline.
Once you hear that Wayfair stipulated to Blake, they're not going to remember it was for trial purposes only. Some may, most of them won't. And if it keeps coming up, they're just going to remind themselves, oh yeah, Wayfair did say that. Nobody's going to remember it was only going to be a strategy that was going to work at trial. So for that reason and for that reason only, if this was Shark Tank, I'm out. Because you played yourself there. You let them play you. Which is why, again, if we were going to go to trial, if they believe they were going to go no longer going to go to trial, they should have taken a second look at this and probably put it in there that you cannot come out here making statements and trying to twist Judge Lyman's hand with this freaking stipulation that's going to follow us for the rest of our lives now.
Elena, thank you for the super chat.
Thank you for the super chat.
Do y'all remember which document it was though that had the stipulation? Because I don't know if that is what the stipulation said. And so I want to reread.
No, I mean, I'm paraphrasing when I say we believe you, but the stipulation, they just kind of gave that up because that was going to be one of the things Blake was going to use at trial to dredge up so many witnesses to say, oh, remember when this happened. I can tell you the document. Give me 1 second. But the whole point of them stipulating to that was so she doesn't get to drag 40 witnesses and kind of pretty much pepper into the jury's mind all of these things and these things happen, which is why we're here. So it was going to work if we had gone to trial, but now that there is no trial, they kind of gave her a shortcut to do all this dirty work. Here, let me.
The docket is 1422.
Okay.
1422. Thank you.
And it says at the pretrial conference, the court asked Wayfair.
Can you put it up here so people can see also, Carol?
Yeah.
All it said is it will be instructed to presume that Miss Lively engaged in protected activity by complaining about or opposing a hostile work environment. I don't know if I thought that was them saying that she believed blah blah blah.
No, but that's on the face of it, it just sounds like protected activity. But what they're trying to pretty much say is she is protected by law to bring this case without anybody assuming malice on her behalf because she has the right.
I don't think it stems from there, Elsie, though. I think it stems from the order that the judge put, because the judge said, like, you didn't do enough to prove that there wasn't malice, so we're just going to say she didn't have malice. I don't think it stems from this document that says, like, oh, we stipulate that it's all good and gravy.
No, I'm not saying it stems from it. I'm saying this document gave them a leg to stand on. I'm saying if this stipulation doesn't exist, they don't get to pull half of the shit they're pulling now.
No, but they are pulling it because of the recent order where the judge said that his finding is that because it wasn't argued enough, there isn't any malice in the recent order. So I don't even think it goes back to this document or that this is the document that gives them grounds. What I've seen is what was in that order, and also the fact that they keep saying that, oh, Lively deserves to be heard. I think I saw a statement that Gottlieb made. What happened to Lively deserve to be heard statement.
No, and I feel like maybe the way I'm speaking, it sounds like this document is actually like a legit foothold. This is not a legit foothold they can use for anything. I'm just talking about what this means outside of if you're not looking at it as a document. Like once this came out, it's almost like it's like an unspoken rule, pretty much. Like you don't give the other side this. Maybe I'm not explaining myself right. If this doesn't ever come out, they don't get to pull half of the shit they're pulling. Is what I'm saying. But they're not using this. Like they can never cite this because this was for trial purposes only. Like they can never come on a docket and say refer to document 1422 for anything. They can never do that.
But they did.
But the remnants of it is gonna linger forever.
I mean, and I think the only reason I brought this up was because Michael Gottlieb did try to bring it up in the hearing, and the judge smacked that down very quickly.
Which is, I mean, that's the judge's job to be able to smack that down, which I'm glad he did. But that's the point: is if Wayfair never gives her the stipulation, Mike Gottlieb never gets to be able to bring it up. But if we were at trial,
I do agree with you, Elsrich, because I've always believed this. It is the thing that pushed them to settle.
Yes,
they wanted to make a circus in that trial, and they weren't going to get it.
Exactly,
so they were going to try to get it elsewhere. Carol, is it okay to put it back?
Yeah. Go ahead and continue reading.
Yeah.
So she only has a few minutes.
Yeah. The parties agree that any and all proceedings related to the pending 47.1 motion will be heard before Judge Lewis Lyman. The Wayfarer parties expressly reserve all rights, all claims, rights, and remedies relating to Lively's 47.1 motion, including without limitation the right to
Oops, sorry.
the right to oppose any substantive or procedural motion, letter to the court, request for relief, or argument asserted by Lively. So the parties agree to irrevocably waive any and all appellate rights associated with the Wayfarer SDNY complaint or the Lively. So anything associated. I mean, I feel like that should close the door.
Yeah.
Anything associated, but does that close the door to Van Zandt?
Oh, it does bring it up. It does bring it up.
Okay.
But if you read B and C again, because that's going to keep coming up.
Okay.
So let's see. So the sorry. It's so B. So this one's going to keep coming up, guys. This part is important.
Okay, so the parties agree that notwithstanding anything herein to the contrary, Lively does not release and retains all claims, rights, and remedies relating to her pending 47.1 motion. The parties agree that any and all proceedings relating to the pending 47.1 motion will be heard before Judge Lewis Lyman. The Wayfarer parties expressly reserve all claims, rights, and remedies relating to Lively's 47.1 motion, including, without limitation, the right to oppose any substantive or procedural motion, letter to the court, request for relief, or argument asserted by Lively. The parties agree to irrevocably waive any and all appellate rights associated with the Wayfarer SDNY complaint or the Lively SDNY complaint, including any appeal of or challenge to disposition of the 47.1 motion, whether by Judge Lyman or otherwise.
So that's the line that makes me think it is done, because they're saying any judgment, any from Judge Lyman or anywhere else. And it's only, and like you said, Bocce, when it says relating to 47.1 motion, but because Judge Lyman said that this is the wrong vehicle to the motion, can Lively's team now say, well, it relates to the motion because the judge quoted it this way?
A part of me feels though like him saying this wasn't the right vehicle was just to say, I feel like maybe if they chose a different vehicle before making this agreement that they would not appeal this motion, then they had a chance. But he's just saying, like, you just made the wrong decision, period. I would like to believe.
Yes,
I don't know.
but Lively. But if you're Lively, and we've seen how they operate, we've seen how they are. What are we saying about this? If we're like this, I, Elsa, we're all reasonable people, but we're dealing with an unreasonable person. Can they follow? We're all reasonable people. Yeah, but Lively and her whole team isn't. And
they're drinking the Delulu Kool-Aid.
They probably need their money.
So in their view, would they see a carve out here? But I think the relating to 47.1 motion, I think you're right. I hope. What did LGA say? Someone said just watch the LGA video. They cannot bring this up again, is what she said.
I mean, and that's what Brian Freeman said.
I mean, they agreed to no appeal. It can't come up ever again. Once whatever the decision is the decision. So nobody can bring it up again, either side. I guess that's the one thing we could be thankful for.
Like, let it be over.
Yeah.
Oh my word. Okay. Immediately upon execution of this agreement, the parties agree to jointly file a notice of settlement reflecting paragraphs B and C and stipulating to the dismissal with prejudice of the Lively SDNY complaint by filing the document attached as Exhibit B. And then the Lively release of claims. So except as reserved above in paragraphs 1B and C, in exchange for the promises and covenants herein, Lively and Lively heirs, executors, representatives, administrators, agents, including, without limitation, Ryan Reynolds, Van Zandt Inc., Family Heart LLC, LOL Hada LLC, or Betty B Holdings LLC, and assigns collectively the lively releasers, irrevocably and unconditionally, fully and forever waive, release, and discharge the Wayfair parties, including the Wayfair parties' parents, subsidiaries, affiliates,
Predecessors.
predecessors, successors, and assigns, and each of its and their respective agents, officers, directors, members, employees, attorneys. I'm sorry, I just laughed with the attorney's line, or insurers. There you go, Harco, no, in their corporate and individual capacities, from any and all demands, actions, judgments, rights, fees, damages, debts, obligations, liabilities, expenses, inclusive of attorney's fees, causes of action, and claims for relief of whatever kind of nature, under any theory, whether legal, equitable, or other, under the law, either common, constitutional, statutory, administrative, regulatory, or other, of any jurisdiction, foreign or domestic, whether such claims are known or unknown, suspected or unsuspected, that the lively releasers may have or have ever had against the released Wayfarer parties, or any of them, arising out of or in any way related to Lively's employment, the film, or the consolidated action, from the beginning of time up to and including the date of execution of this agreement, other than any claims arising from or relating to this agreement. It is expressly understood by Lively that among the various rights and claims being waived in this paragraph 2, release of claims, are those arising under the United States, California, and New York constitutions, California common law, the California Labor Code, Title VII of the Civil Rights Act of 1964, the Civil Rights Act of 1991, the Americans with Disabilities Act, state and federal family leave acts, the Employee Retirement and Income Security Act, the California Fair Employment and Housing Act, the New York State Human Rights Law, the New York Labor Law, including but not limited to the Retaliatory Action by Employers Law, all provisions prohibiting discrimination and retaliation, and all provisions regulating wage and hour law and paid sick leave requirements, the New York City Human Rights Law, and any and all federal and state executive orders, statutes, and regulations. All such claims, including related attorney's fees and costs, are forever barred by this agreement without regard to whether those claims are based on any alleged breach of a duty arising in contract or tort, any alleged unlawful act, including without limitation, discrimination, harassment, or retaliation, any claim for retirement or severance benefits, and any other claim or cause of action, and regardless of the forum in which it might be brought. Does that also close the door in some regards?
Yeah, I think that also closes the door. Retaliation, claim, retirement, severance. Yeah, I think so. I think it seems final.
That's what Brian Friedman was saying. It's done. Lively represents and warrants that she has not assigned or subrogated any of her rights, claims, or causes of action, including any claims referenced in this agreement, or authorized any other person or entity to assert such claims on her behalf. And she agrees to indemnify and hold harmless the released Wayfarer parties against any assignment of said rights, claims, and or causes of action.
Yeah, but it's Lively. She went and did a breach of contract on a Van Zandt against Doe's 1 through 10.
And yet had a subpoena showing exactly that she knew who she wanted.
And she knew she was going to sue, right? Since November. So even so, she'll find a way around this.
Please don't speak that into existence.
I mean, I don't want it to be true, but...
You got to think like the woman.
I don't want to.
No, you have to think like her to maneuver this case. You cannot think like, okay, I think that's what Carol was saying earlier. You cannot think like a reasonable person. You need to allow yourself to become Blake Land around Lively Reynolds. Mentally. You need to start thinking that way. Like, what would a nut job do? I said it. You can sue me. You can sue me. I ain't got nothing to give you. But you cannot think as a reasonable person that lives amongst the rest of us in society. You need to think like an egomaniac, narcissistic person who gets piggyback rides after dinner in New York City.
and thinks for some reason she's creating whimsy in her life through that.
That's who you gotta become. You cannot be reasonable like us.
Yep.
Allegedly. Y'all know I hate that word. I have proof she's not like the rest of us. She
It's
gets
like
piggyback rides after the rest. Okay, the people above my head, allegedly. Me, I say what I said. If you wear polka dot pants with like an ascot looking necklace, and you wear Louboutin shoes, and you go to dinner and you get piggyback rides after dinner, you are not like the rest of us. Therefore, my previous statement is a fact. You can't think like a regular person. You gotta put your mind in the mind of a Blake Lively type of person.
and that's what I'm saying. It's like they gotta put themselves. Even I know the settlement was great for both parties, but I know it was great for Wayfair, and they thought, oh, we're really done with her, and let's put out this statement. But they needed to think how she thinks. I'm gonna use this statement against you. That's how they need to start thinking. How am I gonna use, and then leave no room for doubt in that like statement or anything that they do joint otherwise. They should have known then, but I'm just saying going forward, that's how they need to think about it. Because because they need to know like mainstream is still pulling, Lively's content up at the front and her headline up at the front. Because, all these people have something to lose from Ryan Reynolds not making it out of this. They gotta help her.
Gusta.
Go ahead, Bob.
I was just gonna say, that I'll leave y'all to read the rest of this. I'll probably read it later on when I get back from playing Bocce tonight. But I do want to take the last.
Bocce's going to play Bocce.
I am. I just want to take the last 15 minutes to eat of my actual lunch. But since Elsie is already here,
we could watch you eat.
Huh?
We could watch you eat.
Oh no, I'm not that one of those channels where
mukbang. We can mukbang the rest of this.
I don't know. I'm gonna be eating some tocino and some toron. But that's it. But
me and Carol can hold
just turn off the camera and put it on mute. That way, if you finish early, you can just
you can come in here. That way, you don't lose.
We'll keep reading it. Yeah.
I mean, I highly doubt. I mean, like this is 17 pages, and I think we're on page like 4.
No, it's not that long. The pages is like a statement and all that stuff. You're almost there.
Oh, I am?
Yeah, it's the actual document is only 8 pages.
We can take it over, but we are saying don't end your live. You can just turn your camera and your mic off, and then
turn your camera and your mic off, and then that way.
I don't think it ends it when I leave.
It only ends. It does. You don't remember we had this issue in the past where we did a live together, and when you left.
I think she can leave if she wants to. I think you can.
No, but it ends when you leave. Like if me and Carol keep going, if you leave at minute 43, your channel stops. When you leave. 43.
Yeah.
Like when I joined, my channel is not gonna stream when you guys were here on your own.
Oh, okay. Yeah.
Like when you leave, it stops when you leave. I don't think once you leave.
I feel like I remember watching the channel after I had left, and it was still playing. Y'all.
Oh, okay, then.
Feel free. I think it's only if I was hosting.
And you leave.
And I leave.
Oh, okay, then. Then you're safe.
And either way, y'all, if I'm wrong, y'all know how to go to like Elsie's page or Harold's page, because I think both of them are streaming it anyway. So if you're on my page right now and I go bye so I can eat lunch, I know y'all know where to go. Okay.
Okay, so if you guys are watching on Bocce right now, she's going to do the Irish goodbye. So if you get dropped from Bocce, find Carol. Or find me.
All right, bye y'all.
Bye guys.
Au revoir.
Okay, so she left off on C, right? You want to pick it back up? C.
Whereas, no.
Notwithstanding anything.
Which C?
Under 2C. Do you have your own document, or are you looking at
it? I have it. I'm pulling it up. I just hate that it looks like somebody faxed this over. Like it looks like a typewriter wrote this, not a. Okay. Did she already read notwithstanding? I wasn't paying attention there.
No, she didn't read C. 2C. Yeah.
Okay. Notwithstanding anything to the contrary, I think I heard this. Okay. let's just reread it. Notwithstanding anything to the
she left on there. Yeah, she left.
Notwithstanding anything to the contrary herein, nothing in this release, paragraph 2, or in the agreement shall affect or extend to 1, claims that cannot, as a matter of law, be waived by private agreement, including without limitation, claims of indemnity under California Labor Code Section 2802, claims for unemployment benefits from the California Employment Development Department, and claims for coworkers' compensations benefits, or any claims by Lively or her loan out entity, Blake Link. Horizon. Can somebody remind Sigrid of this once in a while, that Blake is actually not an employee? Because I hate that she keeps trying to do that thing. And Blake is not an employee. She was an independent contractor. But arising after the effect date of this agreement to enforce any right pursuant to any agreement relating to Lively's acting and producing services in the film. Oh my God. Her producing services? Is this like, okay, was this meant for us to laugh? Jesus. Her producing services on the film, including without limitation, the right to receive accounting and payment of contingent compensations, restrictions on the use of Lively's name, voice, and likeness, and the result and
remember the stunt double? She didn't even want the back of the stunt
Right.
double. Ridiculous.
And the proceeds of Lively's services, the right to be indemnified in connection with any third-party claims arising in connection with the film, and the applicable Screen Actors Guild entitlements.
Oh, so she's like, hey, I saw that PGA, remove her PGA, and she's like, nope, that doesn't include that.
It doesn't include that, yeah. You can't win. We actually can never win. The effective date on this agreement shall be the last date on which the agreement is fully executed by the parties.
Mm-hmm.
Wayfair parties release of claims, except as let me make sure people are not saying anything in the chat that we missed, because Bocce is normally good at that. Unless you're gonna keep your eye on it, because I forget sometimes.
Okay. What do you want me to look? You want to look out for the chat, and I'll continue reading?
Yeah, if you want to.
Okay. Wayfair's parties release of claims, except as reserved above in paragraphs 1B and C, which is the 47.1, guys. In exchange for the promises and covenants herein, the Wayfair parties and their heirs, executors, representatives, administrators, agents, assigns, parents, subsidiaries, affiliates, predecessors, successors, and assigns, and each of its and their respective agents, officers, directors, members, employees, attorneys, or insurers in their corporate and individual capacities, including without limitation RWA Communications LLC, collectively the Wayfair releasers, irrevocably and unconditionally, fully and forever waive, release, and discharge Lively and her heirs, executors, representatives, administrators, agents, and assigns, and any of her entities, parent entities, subsidiary entities, affiliates or affiliated entities, predecessors, successors, and assigns, and each of their and their respective agents, officers, directors, members, employees, attorneys, or insurers in their corporate and individual capacities, including without limitation Reynolds, Van Zandt Inc., Family Hive LLC, LOL Hatta LLC, and Betty B Holdings LLC, the release Lively parties, from any and all demands, actions, judgments, rights, fees, damages, debts, obligations, liabilities, expenses, inclusive of attorney's fees, cause of action, and claims for relief of whatever kind or nature, under any theory, or whether legal, equitable, or other under the law, either common, constitutional, statutory, administrative, regulatory, or other, of any jurisdiction, foreign or domestic, such whether such claims are known or unknown, suspected or unsuspected, that the Wayfair releasers may have or have ever had against the released Lively parties, or any of them arising out of or in any way related to Lively's employment, the film, consolidated action from the beginning of time, and including to the date of execution of this agreement. It is expressly understood by the Wayfair parties that all such claims, including related attorney's fees and costs, are forever barred by this agreement, without regard to whether those claims are based on any alleged breach of duty arising in contract or tort, any alleged unlawful act, and regardless of the forum in which might be brought, the Wayfarer parties represent and warrant that they have not assigned or subrogated any of their rights, claims, or causes of action, including any claims referenced in this agreement, or authorized any other person or entity to assert such claims on their behalf. And they agree to identify and hold harmless the released lively parties against any assignment of said rights, claims, or other causes of action.
Real quick, we have a chat, but I cannot put it up because you're controlling the thing.
Okay.
I can only read portions of it. I just realized the 3 dots was quite literally, I thought it was a continuation. Oh my God. Are y'all going to cover the Janable case with equal excellent vigor, please? That one may be even worse for Lively and Reynolds, i.e. Van Zandt. When I saw I thought the 3 dots meant there was more to read. That's why I said I can't see the whole thing. I'm sorry. Yes, we plan to cover Jen. And even like as far as me and Carol talked about it very briefly on the last video, whether or not Janable will have to pay anything. I mean, we would have to wait to see the payment provisions later to see the considerations and stuff to know if Jen will have to come. Did you guys hear that? To come out of pocket. I'm going to go check something real quick to come out of pocket. But yes, we plan to cover the Janable case. I'm going to check my door really quickly.
Okay. She'll be back, guys. Let me see if you guys have any questions in the chat. So they can't go after Van Zandt. What about in the Jones case? It looks like they're releasing. Let's see. Let me pull up that slide. So Wayfarer's release of claims. So in exception of the 47.1 motion. There you go. I'm putting you back in.
I'm good.
So they're asking, they can't go after Van Zandt?
I have to say, honestly, to me, Van Zandt got to fly way under the radar in this entire litigation. It didn't seem like Judge Lyman even gave a damn. Like it never became a thing. Like, and maybe had we gone to trial, we can talk more about Van Zandt. But to me, and even the waiver parties didn't seem to make Van Zandt like a priority. Like they never came at the lively parties on Van Zandt as hard as we were expecting them to. They kind of get to fly away under the radar, but maybe Van Zandt doesn't come into its full glory till we get to the Janable case, because it kind of triggered the whole getting Jen's phone and everything. So maybe we hear more about Van Zandt there, but I don't know. I don't know the answer to that. We're gonna have to read this further or get like a lawyer to answer that. I don't want to give predictions. But I don't know. I wish Van Zandt had more. And I feel like we as content creators and everything gave Van Zandt more of a light to shine, or shone a light on Van Zandt more than the lawyers even did. And I wish it wasn't that way, but what are you gonna do? But
right.
Where did we
stop? We stopped at number 4.
Waiver?
Yes.
Okay.
Yeah. And then also, guys, someone said that because Van Zandt was filed at the state level, it can't be brought up in the federal level. And then also there was never a judge assigned
to that, because they pulled it before it became a thing.
Yes, they pulled it before it became a thing. And so they can't say, hey, judge, you did something wrong. They can't appeal it. They can't do anything, because I'm telling you, Lively, they seem to be operating under different rules and ethics than everybody else.
Yeah. I mean, if you think about, I do think Stephanie Jones and Janable will get interesting though, because looking at the settlement, I think on a surface level, fine, but in the broader aspect, I think it's gonna get good. It's gonna, because Blake Lively might think it's all done, but
someone made a comment about that. Oh,
Steph might not want to save Blake's skin over there, because it might get jumpy. Lively will force Stephanie Jones to settle. She doesn't want any other shady things. That's what I was literally in the middle of saying. And I don't know that Steph might want to save Blake's skin, because If you're Steph and it looks like you're about to, but can she afford to settle that? Because if I'm Jen, I want all of it. I want everything.
No mercy, Jen. Don't show
if
her
I'm
any mercy.
Yeah. If I'm Jen, I want everything. So I don't know.
Jen's not under the same rules, right?
Yeah, she's not. And if I'm her, like I'm acting crazy on that docket. Then again, I'm also not well. So
no, you're a reasonable person.
I am. Oh my God.
All
no,
right,
and
guys.
I think even when we talked to Kevin and we were like, what's next, vacation, whatever, Kevin seems like he's really ready for that. He was like, we're not done yet.
No,
we still got Jones, and he said as much even at court. I think when I asked him at court what they're looking forward to and everything. Oh, somebody just said, oh, I don't see X what? I'm so sorry. What is that? Exterrestrial? Oh, Fritz did say to NAG and LGA that they can bring up a disciplinary action for Samantha. And Van Zandt. That's as far as they can take Van Zandt, according to Fritz.
And they should. They should.
I think
file that.
It's gonna get jumpy. I think it's gonna get jumpy on that docket.
And they need to. They need to make sure they put that. Jen Abel, if she could write to the board, they need to put that in there.
Yeah.
Because that's not acceptable.
100%.
Okay. I like this comment.
Or, yes. Jen deserves to be treated with so much. Yeah. Yes. Which is why when people try to act like Blake is a victim and I'm like, do you know what Blake did to other women? The woman you guys want to support was out here literally putting other women's business in the street because she felt like she was allowed to. And she tried to the funny thing is she didn't try to do it the right way. She actually tried to do it under the table and thought she would get away with it.
Just like she was trying to do 47.1 again, like pull another Van Zandt on Wayfair. And the judge said, no, we're not doing that today. Okay. You want to keep reading number 4?
Yeah, I'll do number 4. Yeah. Waiver of known and unknown claims, except as otherwise expressly stated herein, each of the parties acknowledge and agrees that it may hereafter discover facts different from or in addition to those it now knows or believes to be true in respect to the claims, losses, liabilities, obligations, suits, debts, liens, contracts, agreements, promises, demands, and damages. Somebody put the ether beat behind this. Released by this agreement, and it hereby agrees that the releases contained herein shall be and remain in effect in all respects as complete general releases as to known and unknown claims, notwithstanding any such different and additional facts. In this regard, each of the parties waives and relinquishes his right or benefits that it has or may have under section 1542 of the California Civil Code or any other state equivalent, which reads, a general release does not extend to claims which the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release, and that if known by him or her would have materially affected his or her settlement with the debtor or release party.
So if we're lively, does that mean something?
I feel like if you're a wayfarer and you wanted to back out of the settlement, you want something to come up that you don't know now, so you can use this. But if you're Blake,
if Blake has any haters that wants to turn over a text message,
but I feel like if you're Blake, you want this done and dusted. And you don't want anything to come up that allows Wayfair to be like, we take this back. Because right now I feel like, and I don't want to speak for Wayfair, but I feel like if you ask which party would like to back out of this settlement now, as much as it's still a win for Wayfair, right? But the way Blake is treating this like it's some type of big thing, Wayfair might just be like, you know what? Yeah, let's go back to the drawing board and let's do this.
But if Lively says, hey, I didn't suspect or know that I would have this 47.1 ruling in my favor. So that means I can't be tied to something, the attorney's fees. Does that mean that she's out of this? Because it says a general release doesn't extend to claims which the creditor or the releasing party does not know or suspect to exist. But then she would know, right?
I was gonna say
47.1
with 47.1, it would be her job to know.
because she has that in, like she's expecting to get something out of it. So
Exactly.
I don't think that could
And
be
I feel like it works more if the other side introduces said thing. Like if Wayfair Party sprung 47.1 on Blake, she can then later say, I found this out, but it's her thing. She pretty much introduced 47.1 to all of us. It would behoove you to know what it is, to know what it does, to know what it says.
Right.
So
No,
I don't know that this helps her at all. If there is anything, somebody says turn over some text because we know Blake loves an audience. So they have some of those mumbling, rumbling text messages, guys. I'm telling you. Okay. Each of the parties acknowledges that it has been informed of, has read, is familiar with, understands, and has hereby knowingly and voluntarily waived the rights that it has or may have under section 1542. It doesn't matter anyway.
Yeah.
California Civil Code. Each of the parties further acknowledge that it has been advised by its counsel and understands the significance and consequence of the release provided herein and of the specific waiver of section 1542 of the California Civil Code. Each of the parties acknowledges and agrees that its waiver of section 1542 of the Civil Code is fully informed voluntarily and an integral part of this agreement. Yeah, they can't do anything with it anyway.
So you think it's really done? Did you get to watch LJ's video? Someone said that she read it.
Let's just watch it here. Go on to, can you go here? Let me do it and present it. Is it TikTok or YouTube, guys?
Who watched LJ's video? Did she put it on a TikTok or YouTube? Hi guys, thanks for joining. We're reading the full settlement agreement. It was posted on Megyn Kelly's website. I'm going to go ahead and add a link in the chat. And then I will also add it in the description of the video. Hi Prish. The full settlement was released and we're reading through that right now because of the statements that Lively's team has made that the judge said that they didn't pursue it through the proper vehicle and that they may be pursuing it now. And so it's making this question of like, can they go somewhere else and bring a lawsuit? And they got Megyn Kelly got the exclusive of the settlement agreement. So that's what we're reading right now. I'm going to also put it up on the website on docketupdates.com after the live, so you guys have access to it. But I have added the link to that in the chat, and I will put it in the description of the video. All right, I'll see.
LJ's video is in the it's in the green room if you want to present it.
Okay.
I'll play it.
Okay, hold on.
She looks so pretty.
She does look pretty, yeah.
My pretty girl. Carol, don't be jealous. I have two princesses.
I was just about to say, you know what? She can take the title.
You today.
She can take the title, please.
No, LJ is literally like so sweet. She and Carol are my two girly girls. Okay, all right, let's get this done.
Well, look what we have here. The full settlement agreement between Lively and the Wayfair parties is online for us all to see. Now, I have to take a second to note how unusual this is. And the only reason that we're able to see this is because there is no confidentiality provision in this agreement. There's no non-disclosure, there's no confidentiality, and so hypothetically, we should have been able to see this when the parties entered it way back when they did. So it is unusual for a settlement agreement to be disseminated into the public, but the terms of this agreement warrant it, particularly when they are being misrepresented by the lawyers in the public. Not only does it confirm what we already knew, that no money was exchanged between the parties, but it also elucidates the agreement that they had to carve out 47.1 from the agreement. And the statement that her lawyers made, alluding to or suggesting that they might seek more relief under 47.1 in another jurisdiction, say California, is completely demolished by a clean and black and white reading of what this agreement states. So let's take a look at it together, shall we? So it says in plain English that Lively was retaining her rights on her pending 47.1 motion. And it states clearly the parties agree that any and all proceedings related to the pending 47.1 motion will be heard before Judge Lewis Lyman, which means they don't agree for this to go before any other judge, that all of her rights are going to be adjudicated on this particular matter before Judge Lewis Lyman. And he did, and now it's over because both sides relinquished their right to appeal that decision. This paragraph down here starts to outline all of the claims that Lively agreed to release as a result of this settlement agreement. These paragraphs are designed to cover any potential claims that parties might have lying in wait. And so it is very, very expansive and includes everything. It includes any rights that you might try to assign to someone else. Here, she has released all of her claims. So there will be no suing in another jurisdiction. And there certainly will not be any more tried adjudication of 47.1 or the like involving the Wayfair parties anywhere else. That brings us to the order that was issued by Judge Lyman today, telling Lively that she has by the 22nd to file papers regarding the appropriate measure of her fees and allowing Wayfair parties to respond by June 29th. This means that Lively's counsel is going to need to provide invoices, calculations to show just how many lawyers it took, how many hours it took those lawyers to draft their motion to dismiss and to pursue the 47.1 motion. That's it. They don't get to charge the Wayfair parties for all of the work that they did on all of the other claims. They only are allowed to seek fees with respect to the defense of the defamation claim. So their ledger, their invoice is going to need to be very, very specific. And guess what? We will all get to see it. The Wayfair parties will then have the opportunity to be like, this is not a reasonable amount. For example, if they say that it took 10 attorneys 50 hours each to prepare their defense in a motion to dismiss of a defamation claim, and that each of them costs $1,500 an hour, that is not a reasonable amount of time for that type of work. And they can point to other cases that show what a reasonable amount of work is for that type of motion. Also, Judge Lyman is not new to this. He has granted fee applications in the past. He has a sense of what he's ruled on. And I'm sure the parties will point out, hey, in this case, this other case, you awarded this as reasonable. You didn't award that as reasonable. And so there will be some guardrails within the judge's own experience that he can apply given his own record. But there are also Second Circuit and California cases, plenty of cases that can point to just how much time and how many attorneys it takes to file the thing that they are now being awarded fees for. And by the way, this is not, I have seen so many comments in my videos and others saying, oh, Baldoni's writing a check to Lively. That's not actually how it works. A check goes into a trust account that the lawyers for Lively hold for Lively. And then likely what will happen is that the lawyers will discount the amount that they receive to charge Lively for their fees. So hypothetically, something like this, soaking wet, might be $100,000. I mean, truly, I would be shocked if they got more than that. But let's say $100,000 in fees they're awarded here. That money goes into the trust account of Lively's attorneys, and then Lively's attorneys will discount the $50 million bill or whatever it is that they charged Lively for her prosecution of her claims in defense of her claims, will be discounted by that $100,000 that they receive as a result of this. So in practice, Lively will have either paid that up front or will not have to pay as much. But make no mistake, Lively has spent way more money than she will get with this fee award in everything that she's brought, only to settle this case for $0. So you can twist yourself into the most intricate pretzel I have ever seen. There is no universe that is a win. Well, look what we have here.
I love having smart friends. I'm gonna be a pretzel. I do look like a pretzel though. Look.
I think that I did the math on the 30 million. If they get like 150, it's like less than 1% of her whole bill. So she's getting a coupon code.
No, but honestly, just put it in perspective. I said this to somebody the other day. Blake posted that Hermes bag during the Knicks game that she's probably never seen a Knicks game. And I was like, the amount of money she's going to get from this fee settlement can't even probably, like, if she walked in her closet, she can probably find a purse that costs more than what she's going to get. I don't think the money she gets from this can even pay her driver's salary. The baldy man, the baldy bodyguard that follows her around, I don't think she's even gonna make enough to pay his lying ass because he was ready to lie for her on the stand. We know, allegedly. You can't sue me. I said what I said. A coupon code is right. Groupon. She's getting a Groupon code to pay her attorneys because she's not getting enough to buy the mahjong set, buy lunch, and a purse. The amount of money she gets from this can't pay for her and Ryan Reynolds' vacation this summer if they wanted to go on one. So I don't know why she's wasted everybody's time like this, but as long as
and we will get to see it. That's the thing.
That's what I'm saying. As long as she's still want to act the fool, I'm tuned in, baby. I'm tuned in. Never change, Blake. Stay natural, girl. Stay true to who you are. Duh me. My God.
She's handing you the content at this point.
You know what? I can't even make it up. I cannot write the script even if I wanted to. Like, why are you doing this to yourself? And I will say, nobody cares about her in the house. Not her husband, not her mama. She doesn't have friends and family. Her lawyers don't give a damn either. Because as long as this is going, baby, they're still billing you.
I think just filing it will probably be the amount of fees that she's going to get.
You think Mike Gottlieb is going to be like, you know what, girl?
Let's ask this question.
All women.
It's like, do we really think the lawyers will try to ask for some crazy amount of money? Wouldn't they submit accurate info because it's on their name, not Blake's? They're still advocating for their client.
Or their client.
Right? So they're going to try to make that number as big as possible. But I think even if they try to make it as big, like let's just think like 300,000, double whatever NYT billed for dismissing the defamation claim, right? So we're going off of that number. NYT said it was 186,000. Let's say Lively even tries to double that. I think it still looks silly from her to file for a 300,000 invoice.
Yeah.
And if she goes higher than that, then that's the whole like statement of like, she's Delulu. Yeah.
They're gonna have an invoice there. We had a steak dinner at whatever. It costs $2,000. Get the heck out of here. We discussed the settlement over a steak dinner. This is the invoice. Because lawyers bill everything. They bill everything. So I would actually love to, I want to see I think I'm more interested in seeing the little details and what the amounts are more than I am interested in the, whole dollar amount. And this is assuming they're going to be honest here. Like, oh, we met with Blake here, whatever we took, and it caused this, and I'm going to be looking at her like, girl, these people don't like you. Because if you're Mike Gottlieb and Ezra, you guys should have told this lady very early on. Even if you win this,
we're talking about pennies at this point.
We're talking about pennies on the dollar. Like, you're not getting shit back.
And Mary's saying, like, it's their name, and their reputation in the court. They filed Van Zandt. Manat did that. Do they care about their reputation? No.
They try to go under the table for 47.1. Ezra did that. They don't care. They do not care, not one dang.
They're trying to take the law away from Victoria Burke. They don't care. They don't care at this point. So I just don't
as long as the check clears, they're like,
I think that's why they have to. They're waiting for their payment too.
Yeah, I think as long as the check clears, they're on the job. They're like, hey, we're here for you. You're the client. Your word goes. And there are lawyers in this world who will dead ass sit their clients down and take themselves off the job and say, hey, we don't feel like, this is important. And you know what? I want to challenge Manat Phelps and Michael Phelps and what is the name? What is the law firm name? Manat Olympic Swimming, whatever it's called. Phelps. I always want to call them Phelps and Phelps, whatever. I want to challenge them. Since you guys believe Blake so much, as your client, why don't you just give her this thing for free? When this case is said and done, just don't charge her. You guys believe her as a woman. You believe she was wrong. So why don't you just write off the entire 2-year litigation? Yes? Yes? Can you pledge that, my godly Ezra?
Wait, are you going to ask that in the next hearing?
I literally wrote that in my notes, and I was like, that's what I want to ask Sigrid. Hey, you guys, since Mike is not here and Ezra is not here, I just wanted to ask, as a woman, you guys believe women and you support women. I think one thing you can do for Blake here is make this a pro bono case, no? Dummies. Watch Sigrid say some shit like, what is Sigrid's opening line again?
She said, what we're seeing here.
So wait, you're gonna be Sigrid. Hey Sigrid, great outfit. Just a quick question. And we were all wondering, considering we believe women and you guys believe Blake has her attorneys, and it looks like she's gonna get a bag of chips and a Subway sandwich from this litigation when it's all said and done. Why don't Manat Phelps and you guys, your entire lawsuit, why don't you just, make this case a pro bono, like a real pro bono, maybe hold a concert, even donate. Crickets? No, nothing.
They gotta get paid.
Watch TMZ. Maybe it's just the principle of the matter. They still gotta get paid. No.
Next time, just jump in and say, let her answer, please.
No, seriously. No, Sigrid is going to be like, what we're seeing here, it's not about a pro bono case. It's about an employment. Actually, Sigrid, your client is not an employee. It's not an employee. She's an independent contractor. Yeah? You agree?
Someone said, what we're seeing here is.
You guys, I'm not even joking. If I forget, if we go to a hearing, flood the chat with pro bono. Pro bono. I'm gonna make Blake Lively's case a pro bono merch, and then I'm gonna make sure Ezra and my godly can answer that question.
This comment is for you.
Oh, Elswitch, did you see that some channel referred to you the other day? What channel? You guys, I don't consume a lot of content, so
thank you, Jody.
Oftentimes, thank you for the chat. Oftentimes, I'm hearing things from you guys. Because by the time I'm done making my own content, talking to Carol, talking to Bocce, like Carol texted on Saturday, and I just saw it today.
And I don't hold it against her because I know she'll look at it when she can.
Like my life behind a camera, like you would think it's not real. So I don't watch a lot of other people's contents. So I don't know. What did they say? Was it a bad reference? Because I would like to answer.
DM her, guys. We don't want to unleash Elsie here.
No, I'm composed. I'm a reasonable person.
Oh, okay. So let's finish reading the thing.
Let's finish, yeah.
Okay. We're at number 5, right?
Yes.
Okay.
5? Did we? No, we didn't read 5.
Yeah, I'll read it. Third-party exclusions. The parties understand and acknowledge that releases in this agreement, including paragraphs 2 through 4, specifically exclude a release as to any and all demands, actions, judgments, rights, fees, damages, debts, obligations, liabilities, expenses, inclusive of attorney's fees, causes of action, and claims for relief of whatever kind or nature under any theory, whether legal, equitable, or other, under the law, either common, constitutional, statutory, administrative, regulatory, or other of any jurisdiction, foreign or domestic, whether such claims are known or unknown, suspected or unsuspected, by or against Sloan parties, the Wallace parties, the Jones parties, or the Times. For avoidance of doubt, the Wayfair parties are not authorized to act or enter into any agreement on behalf of the Wallace parties or any of them, including, among other things, binding the Wallace parties to the above stated waivers and exclusions. This agreement also does not release any claims or demands by a third party against the Wayfair parties or any of them for indemnification or reimbursement of attorney's fees or cost, or B, by the Wayfair parties against their insurance carriers for coverage. Go ahead, Elsie. Read 6 and 7. Oh, wait, you're muted.
I got it.
Okay.
The parties acknowledge that the promises and covenants in paragraphs 1 through 4 and elsewhere in this agreement is something to which they would not be entitled except for their decision to sign this agreement and to abide by the promises made herein. Ambiguities, all parties have participated in the negotiations of this agreement, and thus is understood and agreed that the general rule that ambiguities are to be construed against the drafter shall not apply to this agreement. Wait, what does that mean? In the event that any language of this agreement is found, in the event that any language of this agreement is found to be ambiguous, each party shall have the opportunity to present evidence as to the actual intent, of the parties with respect to any such ambiguous language. Okay, because I was like,
yeah. So the section number 5 was just excluding whatever is open between Sloan, the Wallace parties, Jones Works, etc. And this is just saying, hey, they're going to. But we're not an attorney, guys. It's just what we're gather as in layman's terms.
Yeah.
In plain English.
In plain English, the English language says, I'll read 8.
Okay.
Enforcement and remedies, choice of law, dispute resolution. The parties agree that this agreement shall be deemed entered into Los Angeles, California, and that the internal substantive laws of the state of California applicable to contracts made and performed entirely in California shall govern the validity, interpretation, performance, and let me turn this light down because it's going to blind me. Performance and all other causes of action, whether sounding in contract or in tort, arising out of the relating to this agreement, except with respect to California's presumption against extraterritorial application, which the parties expressly disclaim. The parties hereby waive any argument and covenant not to assert the California law does not apply to this agreement or any of terms herein, including with respect to extraterritorial application of California law. Any dispute or controversy arising under or in connection with this agreement shall be exclusively submitted to and resolved by confidential, binding, and final arbitration before JAMS. Oh my God, we haven't heard JAMS since like last year around this time.
Oh, I don't even remember seeing them.
When like JAMS came up, yeah. In accordance with the provision of California Civil Code 1282 to 12843, with the exception of 1283. The arbitrator shall have the power to grant equitable relief, including injunctions, temporary restraining orders. I don't know that this matters anymore, though.
Yeah.
This is like, I guess it's just you put the language in there because you have to. But right now, like an arbitrator never even came up. As permitted by applicable law, the parties initiating arbitration will be, imagine they're like, yeah, let's go to arbitration now, guys.
I think it's if something is against this agreement.
Yeah.
Yeah.
But I would still be here for bullshit like that because it will be interesting. Because are you kidding me? Arbitration at this hour? Like we don't have anything to do. As permitted by applicable law, the party initiating the arbitration will be responsible for paying the filing fee for the arbitration required by the arbitration service provider, and the arbitrator may permit the prevailing party to recover its cost and attorney's fees, if any, to the extent permitted by applicable law. Any award pursuant to said arbitration shall be accompanied by a detailed written opinion of the arbitrator setting forth the reason for the award. In the event that any arbitration action, suit, or other proceeding is instituted to remedy, prevent, or obtain relief from a breach of this agreement or arising out of a breach of this agreement, the prevailing party shall recover all costs and reasonable attorney's fees incurred by such party in each and every action, suit, or other proceeding, including any and all appeals or petitions therefrom, as provided by California Civil Code 1717. This agreement to arbitrate is freely negotiated and mutually entered into between the parties. By entering into this agreement, the parties are waiving all rights to have disputes subject to this agreement heard or decided by a jury or in court or in a court trial for the avoidance of debt.
Yep.
For the avoidance, that was me, sorry, for the avoidance of doubt, such agreement or arbitrate shall not apply to Lively's reserved claims, rights, and remedies relating to her pending 47.1 motion.
But it talks about pending 47.1 motion. It doesn't say like a new lawsuit, a new something. It says relating to this motion, pending. I'm just thinking, can she say, well, it's because it relates to this motion somehow?
She would find a way. Leave it to her. Leave it to her to find a way.
We only have a little bit left of it. It's these two next slides, and then we're done.
Okay. Admissibility of guilt. Do you want to do? Oh, you want me to?
You could keep reading.
Okay. Admissibility of. Did I say guilt?
Yeah, you did.
Oh my God, guys. I want to go to trial so bad. I want to be in somebody's trial so bad. My brain is like guilty, even though this case really would have never had a guilty verdict or anything. Anyway, admissibility of agreement. I'm so sorry, guys, because I was reading what the chat was saying and my brain was like, the parties agree that this agreement is admissible for the purpose of proving up or enforcing the terms of the parties' agreement and set forth herein pursuant to California Evidence Code Section 1123 and California's Code Section 664.6. The prevailing party. I wish I knew these off the top of my head.
Yeah.
If I read them, I'm like, what does it actually say? So my brain is like, no, you don't know what it says. The prevailing party on a motion to enforce the settlement agreement is entitled to attorney's fees and costs. Entire agreement, except to the extent otherwise expressly provided herein, this agreement constitutes and contains the full and complete understanding and agreement between Lively and Wayfair parties with respect to the within subject matter, if any, whether written or oral, supersedes the MOU between Lively and Wayfair parties and may not be modified or amended except by a written instrument executed by all parties hereto. This is an integrated document.
And it says, you see the comment?
The Honorable Judge Elsrich. Guys.
Someone said, did Blake Lively sign this agreement? Yeah, she did. We'll show the slide.
Yeah, everybody signed it. Did she put a heart or a dragon next to her signature? I have to check.
Oh my God, that's so funny.
What if she actually like drew a little dragon? Or she put like a Game of Thrones sword.
We'll bring up the slide so everybody can see it. Yeah, just read the last paragraph. No,
11.
there's 5 more paragraphs.
No, there's more. There's more. It goes up to 16, and then there's like a big blurb.
Yeah.
All right. Counterpart execution, electronic signatures, and use of photocopies. This agreement, so if they did electronic signature, she did have a chance to put like a dragon emoji.
Perhaps, yeah.
Agreement. If she does, I'm going to die. I don't think she would. This agreement may be executed in counterparts, and each counterpart, when executed, shall have the efficacy of a signed original. The parties will be bound by signatures made by hand or signatures made by electronic means on the signature line of this document. The parties agree that such signatures are binding and may be transmitted by mail, hand delivery, facsimile, email, and or any other electronic methods to the other party, or if applicable, counsel of record for the party, and will have the same binding effect as an original ink signature provided, however, that the agreement may only be modified by written instrument. Copies transmitted by email, portable document format, PDF, or facsimile, or photocopies of such signed counterparts may be used in lieu of the originals for any other purpose, any purpose.
I'm glad they spelled that out for her.
Yeah. She needed, well, hopefully her lawyers read that to her because, she can't read. Severability. If any portions of this agreement is found to be illegal or unenforceable, the rest of the agreement shall remain valid and enforceable unless the other party elects to cancel it. Because I would. Let me find out one part of this is illegal. The whole document is in the trash can. It's in the basura. Throw it away. I went Spanish real quick.
Wait, else Rachel, take a look at this.
They drew stick figures for her. They show her the color book, the color book version of this. Oh my God, I love this community so bad. I love this community so bad. Oh my God. Okay.
Okay.
You guys don't get sued, okay? Effects of waiver. Allegedly.
Where's my banner?
Oh my God. No, you guys remember when I used to have the tree? And I would write allegedly, and stick it in a tree.
I remember that.
I'd be like, I need to have a allegedly thing in this corner. Maybe that should be the new name of my thing. Elsearch allegedly. I love that I actually never used that word meaningfully, and I'm fine. I'm so proud of myself. No waiver of any breach of any term or provision of this agreement shall be. Christina, you definitely remember that. Christina was here for that. Of this agreement shall be construed to be or shall be a waiver of any other breach of this agreement. The failure or waiver of any party at any times to require performance of any provisions hereof shall in a manner affect the right at a later time to enforce the same or any other provisions. No waiver shall be binding unless in writing and signed by the party waiving the breach. Amendment only in writing. The agreement may not be amended except by an agreement in writing signed by the party, all parties to be charged or bound by such amendment. Paragraph descriptions. The use of headings in this agreement is only for ease of reference, and the headings have no effect and are not to be considered part. So maybe no pictures for Blake. If we can't even use headings like that, then maybe no pictures. Consultation with counsel. The parties acknowledge that they have carefully read and fully understand this agreement, and that they have had the opportunity to consult legal counsel of their choice. I'm down now, Carol. Okay. I'm reading my own, but I'm down. Of their choice in connection with this agreement and consent to all the terms and provisions contained herein knowingly, voluntarily, and without any reservations whatsoever. Please read carefully, Blake. This agreement contains release of all known and unknown claims. The undersigned agreed to the terms of this agreement and voluntarily enter into it with the intent to be bound thereby. This agreement is binding to other parties. You do not have the right to take authorship over this. I'm so sorry. The rest is me. It stops at binding to the parties. All right. So
and there we go.
Like Lily's signature.
That's her signature right there.
What the hell is that?
A scribble.
I'm so dead ass. What is that?
It's a B and a B. So I think she goes by Blake Brown.
No, wait. What are you seeing?
I'm telling you, the signature.
Above Blake's name? You see a B and a B?
Yeah.
Oh, that's a big B?
Yeah.
And then like a bunch of nonsense?
Look, let me see if I could zoom into it.
I'm zooming in at home. And here, show my tab because I'm zooming in at home.
Okay.
This is a B?
Right there. Right. No, so, the next B. Okay, so that's a B.
And where's the next B?
Right there's a B. Up, right there. Down. Right. Yeah, that's the loop of the B.
That looks right so there. Wonky. Oh my God. I mean, you can't judge a person's signature because people literally draw a line. Because Melissa Nathan, what is this?
Wait, look at this.
Steve, sir, you are a billionaire. This cannot be. Steve, come to the front. I'm judging all of you.
No, they use the Adobe, like, just sign my name.
I know, but there is no way.
Look at Bocce's comment, and turns out Blake wasn't the one who signed it. Ha! That's a joke, guys. That's a joke.
Funny. Somebody said she made a spelling mistake. I'm dead. I'm dead. I am dead. You guys, this is insane.
Bocce said, "Mary, that's really funny."
Wait, everybody signed their stuff on the 6th. Why did she sign it on the 7th? Wait, was the
Met Gala?
I'm so serious. Did she sign it after she came from the Met Gala? Or when
was the Met Gala?
I'm looking it up now. Wait, the Met was May. No, the Met was the 11th.
Okay, so she signed it before.
Wait. No, it's supposed to be the first Monday in May.
So the 4th. She hadn't signed it yet.
So everybody signed it the 6th, and she took hers 3 times?
Mm-hmm.
Interesting.
She executed it.
She would be the only one to sign it last, though. It's interesting that she's like everybody else, 6, 6, 6, 6, 6.
Mm-hmm.
Blake 7th. I'm gonna stand out from the rest of these motherfuckers. I'm not like the rest of them. Wow. I'm dying at these signatures. Justin, literally.
These comments, guys, are hilarious.
That's a big B. A bunch of nonsense. No, dead ass, because what is this? Jamie just didn't even show up. I don't know what that is. Melissa Nathan is sending me up a wall. Steve, big body billionaire, dead ass said, I'm gonna just write my name. Justin too. Justin is like, I'm gonna just give you a nice little quick handwriting. Like
a nice sign to choose your signature. Yeah.
Yeah, this is hilarious. Do you think this is what Steve Service puts on a check? Cause Steve, run me a little coin, run me a little something.
Run me a little coin.
Give me a little blank check. Let me do something with it.
Oh my gosh, Prish, this is so funny. She signed it angry. Hey, as long as she signed it, we all doubted.
Now I want to see her signature on her other contracts to see if the anger is evident. I want to see her other signatures. Oh my God. Do people actually ask for Blake Lively autographs or just pictures?
I'll see this comment.
Oh my God, she was buzzed. She was Betty buzzed. Oh my God.
That's the non-alcoholic version, guys.
She was Betty boozed.
And they sign like doctors, right? That's really funny.
That is funny. Jesus Christ. Guys, oh my God. Okay, so her autograph is different. Her autograph is different. I'm looking at some of her autographs and it's not, I mean, you don't want to put like your legit signature as an autograph because then, but I mean, some people do though. Some celebrities have their,
yeah.
But I'm looking at Blake Lively autographs now. If you want to show here.
Okay.
It looks like the B, this kind of has like, it's in there too. You see this little bit?
I'm like, maybe if I turn.
It looks like it's part of it. You see this part of it here?
Mm-hmm, mm-hmm.
Can you see my screen?
Yeah, yeah.
It looks like this part of it, it's kind of this part of her autograph in a way.
Oh, yeah, I see it. Uh-huh.
Right? And then if this is maybe the big B here, here, like the big B that we were talking about.
Mm-hmm.
Oh my Lordy Lord. Yeah. Anyway, a mess either way. But I'm also like a certified Blake Lively hater. Whatever the signature looked like, I was gonna find a way to hate. I'm not ashamed. I'm not even ashamed in my game.
The signature is as frizzy as her hair.
Wow. You guys see, Carol is meaner than me.
No, I'm not.
Carol is meaner than me.
I just got jokes.
Deniability. She's gonna later say that's not even her who signed that. She's gonna say Ryan mimicked her signature in her sleeve. Blake signed because Mahjong was withheld until then. I'm dead.
Mary, it looks like I do the checkout.
She finally signed a contract. I'm dying. My God, you guys are funny.
You guys have jokes too.
Hilarious. No, I love it. Oh my God, I love it. That's actually hilarious. TMZ would not get that. If we made a Mahjong joke, TMZ would be like, huh?
Why? Why are you guys
Why are
saying
we bringing Mahjong? Oh my God. Like, you don't deserve
Well,
to.
they reported it.
No, seriously, like it annoys me. You don't deserve to be in this conversation. If you don't know what the basement thing is, if you don't know what the Mahjong thing is, why are you here, fam? Why are you here? Maybe Ryan signed up to. You win the internet. Put that back up because that is actually hilarious.
Wait, pull up the signature.
Let's pull it up and let's pull up. You have to show the screen. That is
Okay.
actually hilarious because I am so dead ass. That is hilarious.
He wanted to be part of this so bad.
The funny thing is, Ryan probably signed it first, then Blake signed over it. She got to go second. Oh my God, that is hilarious. Let's see what Ryan Reynolds' autograph looks like. See if we can find remnants. I'm dying. Are you shitting me? Guys, if we look closely, Ryan Reynolds' signature is in there. Look. If
No! Wait, hold on.
this is it, guys,
he definitely signed it.
it's in there. It's in there. Go
It's
back.
an
Go back.
Easter
Go
egg.
up to the tab. It's in there. I see it right there. I see it.
It's an Easter egg.
It's definitely a Taylor Swift, Blake Lively, Ryan Reynolds. Wait, did Taylor also sign this? Let's see. What is Taylor Swift? No. That is actually the funniest comment. Maybe Ryan signed on top of her signature. No. Oh, you guys, it was like cutting a birthday cake. They held the pen together. You know when you have to cut your cake with your
Look
best
into each
friend?
other's eyes. Let's sign it together.
Action. Cut. Let's do it again. Or maybe her 4 kids. She didn't want to be left out, so all the kids signed it.
There's a little drawing of the kids.
They're gonna turn this into a purse later, guys. This is gonna be a $10,000 purse later on Judith Lieber or whoever the lady's name is. Rug pull. Oh my God. You guys are insane with these jokes. Rug pull is actually hilarious.
I call him plantation pool.
That is insane. Megamind, Plantation Barbie. What is the other thing? Khaleesi, Plantation Khaleesi, Plantation Pool. Ooh, Plantation Pool eats.
Oh my God, this is so funny.
She's too shy to sign it alone. Lights, cameras, action, guys. No.
Oh, you said it first, Gloria. Sorry, I missed it.
I can't sign this. I need my kids. Oh, maybe while she was signing it, her kids were holding hands behind her. We shall overcome. We shall overcome. We shall overcome. Oh, Lordy.
It took her a minute to understand rug pull.
Wait, who said? Oh God, Bocce. Wait, you really? Oh my God! Now we need another game. We need another one of those. What's it called? The games we did, and a rug pull joke has to come up. And like, Bocce's gonna be mad if she doesn't get that. When this is said and done, I think we do deserve another the game. What is it? What is that thing called? Jeopardy.
Yeah.
Who wants to be a millionaire? Not Blake. Not Blake. And then we have like pretty much an
Bro, that's a good one. Someone in a game show will win more fees.
No, that is so funny. That is so true. Slumdog Millionaire.
Someone in a game show someone in Survivor will win more than Blake in this 47.1 fee of attorney.
She really has a better chance of playing the lottery. If I'm her, play the lottery. You're gonna get more money from that than this. No, but I think
do we look? Sabashi says, "Oh wait, maybe I don't know what it means."
Why don't you know what it means? Rug pull, but make pool like a U instead of pool, but rug pull. Like Blake, I pull the rug from under people after I get the job. Pool.
Yeah.
Bocce. If you don't know that, you on the same level as TMZ. Bocce, respond quickly. If you don't get that, you and TMZ are the same kind of people. I thought it was a joke about the hair. About his hair. Whose hair? Ryan's hair?
Ryan, I don't know. Never mind. I won't say it.
Text it to me in private chat. I'll say it. Jump to conclusions, Matt Rugbo.
Bocce is too cute. She's like, maybe I
Bocce,
am.
somebody said Bocce. Wait, Mary said Bocce's in her post-food lunch coma. Oh my God. That
yes,
is
Jungle. That's what I was going to say.
Oh my God.
Yeah, he has a few years to hang on to that.
You
Maybe
guys,
the next 2 years.
We're actually insane.
But that's it, guys. We just covered the full settlement. I added a link in docketupdates.com under latest news. I did credit Megan Kelly with the exclusive, but I went ahead and added the full settlement document in there and a link to her website if you want to read all of Brian Freeman's statements. Go ahead.
Put this up, Carol. Oh, I guess it's already up. You guys, breaking news. I guess they settled with the contractors.
They don't want the contractor speaking out.
They're saying Blake and Ryan have paid off their $2 million debt to the contractors.
We did it, guys.
We did it, Joe. We did it. Oh my Lord.
We're making these people be nice.
I mean, because I feel like they're like, yeah, we can't keep going down with this. This is a monstrosity. Wait, and Carol and I were discussing this. If you share a bed with your 16 children, why do you need this house? I'm asking the questions that people want to know. You guys know how I do. If we're sharing the bed with our 16 kids, maybe the rest of the house is for the nannies. Because I don't know why you need all of this real estate if you're sleeping in the same bed with your kids every night, according to you, sister. You say the kids be in the bed. And the way I see it, you could use just this little portion here. I don't know what that is. Or it could just be this part.
Yeah, why do they need 14,000 square feet?
If you share the bed. Unless you were lying.
Well, didn't they say they have like 16 bedrooms or something like that?
Something like that. I mean, it is Buckingham Palace. It is Buckingham Palace. Somebody said, what an eyesore.
No, that is not that one. I missed it. Sorry.
No, it's right there. Wait, you put it up, then you took it away.
Oh,
yeah. Oh my God, that is hilarious. No, but I really want to know why would you have all of this if the kids are all in the same room? She belongs in her own basement.
Stop.
I'm dying. Oh my God, you guys.
Kenny,
I mean, I guess eventually the kids are gonna get out of the bed, but will they let them? Because they're co-sleeping family.
I think she just said that to bring up something else to complain about.
And you know that. You know that. But the fact that she actually thought that was a conversation starter and then try to turn that on him, I told him that, and he knows we do that. So when he brought it up, it was definitely meant to make me feel.
No, girl, we're just laughing at a joke. Calm down.
Like, why would you even volunteer that information, number one? And then after volunteer it, a person who also had, like, I don't know what goes in her. Like, what? Like, I don't get it. I don't want to get it, actually. Because I might lose brain cells if I try to get it. So I don't want to get it. But that is hilarious. So, but at least it's good, though, that these people have been paid. Hopefully. Unless they send them like a promissory note, like an IOU or something. I don't want to read what TMZ actually has to say about it because I don't truly care what TMZ has to say. Yep. But all we know is there's no word on when construction will resume. Okay. And I'm okay with that. Maybe she's waiting to get her $100,000 from Justin to start construction.
They don't know when they're going to get more free labor.
That is wild, Carol.
I need to get this off. Okay.
No, I have so many questions for Sigrid next time I see her. I'm going to make sure I ask about the pro bono. I'm going to be like, are the constructors really paid or was it an IOU? Sigrid is going to bucket.
Guys, you're so funny today.
Nobody's scared anymore. They're like, this case is settled. I'm talking shit now. Everybody's like, get your shit off. This case is settled anyway. They can't sue me. I really should make a merch that says you can't sue me. Watch her sue me for that. Oh my God. No. Oh, no. Blake paid the contractors, not. Oh, so people were asking earlier, I was seeing. So no money really exchanged hands. I was hearing that Blake paid Justin to settle. Guys, the lawyers came up here and told us. I don't know where this whole Blake paid started.
Mm-hmm.
But even Kevin came up here and said they didn't pay anything. They didn't take any money. Like no money went anywhere. Justin didn't pay Blake. Blake didn't pay Justin.
Mm-hmm. No one, and if we read the whole settlement, guys, it's available on docketupdates.com. It's available at the Megyn Kelly link. There is no reference of an NDA or any money switching hands either this direction or that direction.
Yeah.
But if you guys want to start rumors, you guys can.
Go ahead. I'm gonna back you up. Let me just give me a little bit of proof. I don't need a lot. Just give me a little bit. And I'm like a dog with a bone. I'm gonna run with that shit on this internet. Because I'm not scared.
Oh, you know what? Someone said Justin and Blake pay the contractors. No, Ryan.
No, Ryan and Blake. Why would Justin be part of this at all? Carol, take it off the screen. I don't want to spread misinformation.
I'm taking it off.
Let's go back to the signature.
I was gonna say, you know, that just shows like how Wayfair deals with people. They paid Blake even before she signed. Mm-hmm. The laborers worked for free. They didn't even get paid.
Wait. You guys are saying there's scheduled, there's hearings scheduled? Don't play with me. Don't play with me. Don't play. Give me one margarita. Give me two margaritas. Give me three. Don't play with me. Don't you play with me.
No, not yet.
Why y'all lying like this?
It just says set deadline /hearings, but there's no hearings yet. Oh, I need to update the website as well. So I'm going to update the website with that latest update. I'm sorry, guys. My dog's barking.
No,
I'm going to
okay.
myself.
I think you were are you referring to the order that came out earlier? Carol, pull my thing up if you can. That we've seen. We've seen. Are you referring to this? Whoever, I forget who left the comment.
Yeah, because the order says order and until set deadline /hearings. This document only sets 2 deadlines. I'm going to add those to the calendar right now. But Elsie, if you could read that for them while I add that to the website.
So this came earlier before we found out about this Megyn Kelly exclusive. So the court has issued an opinion and order regarding liability for attorney's fees and costs under California Civil Code Section 47.1. By June 22nd, the Lively side shall file papers regarding the appropriate measures of fees, which is when Blake Lively is going to tell us what she thinks she deserves. And the Wayfair party shall respond by June 29th. So by June 22nd, next week around this time, Blake is going to tell us her invoices, her billing record, everything that she thinks they spent to file the dismissal and everything to defend 47.1. And then by June 29th, Wayfair is going to respond and be like, that's a bunch of bullshit. That does not cause that. And then the judge is going to be like, okay, everybody come see me a hearing and let's talk. And that's when me and Carol will get on that plane. But we don't have that date yet. You had me ready to pounce on the airlines. I was like, get me on a plane now, today. No, but we don't get to find out about the hearing. It's definitely going to be in July because the Wayfair doesn't have to respond till June 29th. And I doubt that he's getting that response and making a decision by June 30th or whatever. So whatever the hearing is going to come after in July or August or whatever. I don't think it will take 2 months to get a hearing. I don't think, but this is all we got earlier today. So you got me excited. You got me ready to go, but no, not yet. Let me see.
I got excited too. I thought it was something.
No, because I was just telling my husband the other day, I'm like, I do not want to, because our flights to go to New York, that quick trip was so expensive because we had like a day's notice.
Mm-hmm.
So I was like, I definitely, if this time around, if I play my cards right, I could buy a ticket for half the price. So I just want to make sure if we get a notice, I'm jumping on that. Somebody said the dynamic duo flying again. Yeah. Me and my princess girly. You guys, Carol is literally so cute. She would be like we only got to like travel for like 24 hours, but I think she'd be a really great travel partner. She had everything in her bag. Literally everything was in that bag. She had a sewing kit, guys. We were there for 24 hours. She had a sewing kit. What was I going to sew? And she had it laid out too. Carol, sweetie, Why are we amending clothes, ma'am? It's a 24 turnover trip. Why do we have a sewing kit?
I have everything in that bag.
It was insane. I saw that sewing kit and immediately knew I was traveling with a grandma. Because who has a sewing kit in 2026? It was hilarious. No, and then we got in a car and it started at the courthouse because it was so hot. We were sweating, right? She started pulling out these patches that collect like excess oil and excess sweat. I was like, what the hell is this? She's like, girl, take more. I was like, I don't know how to use these. We're in the back of the Uber and I'm trying to blast the AC, but it's New York. Even though like they all keep their windows down. I'm like, what are you guys doing? The windows are down. I'm like, it's hot. And I'm trying to patch.
They're trying to save on some gas money.
Oh, watch this. Elsie said she can never travel with me. Haha. Girl, y'all. No, I don't want to relive that. We're not reliving that moment. That was stressful. No, but I would travel with you. Absolutely. I would travel with you. Because then you wouldn't be in that position. Because Carol can tell you what happened to me the night before. And I was like, girl, I'll call you back. I'll solve my situation in 30 seconds. I freaked out for 30 seconds and I solved my situation in 30 seconds. And I was there. We made it to dinner like at midnight, but I was still there. But did I find my straw? No, guys. I never found the freaking straw. Carol.
What straw?
Remember when we got the pizza and the ginger ale wasn't cold, so they gave me the cup of ice and the straw?
Yeah.
And we sat down and I went to wash my hands and you were doing the live. I came back, the straw was gone. And I was like, oh, maybe you dropped in my purse. Guys, I literally was searching for the straw at home. Still didn't find it. Never found the straw. And the pizza got so cold when you were eating. I remember seeing you do like a cheese pool. I was like, oh, that looks. By the time I was done being a chatterbox,
I
sat down to eat. It was like eating like a glacier ice from Alaska. I almost thought about taking the pizza back to the people and be like, hey, I bought this from you like 2 hours ago.
Can y'all throw that in the oven again?
You think you throw it in your oven? And I was like, they'll probably be like, ma'am, that goes against multiple sanitary rules or whatever. So I just sat there and I gnawed on that hard. And then I drank my ginger ale. But guys, no, I didn't find a straw. Oh, you guys are asking about my drama the night before in New York? Is that what you're asking? This comment from Tuka Time continues. Is that what you're asking? Oh, no, you're asking about NAG. And let me know if you're asking about my New York drama or the NAG thing. Because
look at this.
Carol is like Mary Poppins.
That's what she said.
That's what I said. That's literally what I told her. It was like a bag of tricks. She literally had like a clown bag. Literally, we were in a car. She was like, you need a light? You need a tripod? You need a snack? I was like, Carol, what is in that bag? No, it was wild. Oh my God. No, but I would definitely travel with both Carol and Bocce again.
That was really fun.
Somebody said Elsridge took such good care of Carol. She'll tell you. No, she took care of me with gadgets and stuff, but I took care of her like legit. No? Carol, you can't just laugh. You have to back me up. Did I not take care of you like the little princess that you are?
No comment.
I'm never doing it again. You're on your own next time, Missy.
She
you
was
stay,
like,
you stay at home hotels. You
was like,
cars.
She was like, let me get you some tacos. You're hungry.
You're hungry. Let's feed you. Let's feed you. No, you guys should have been with us.
Guys. No, she really did.
Should have been with us at dinner the night before. That was funny.
That was so cool. I mean, I wish Bocce was there too, but
yes,
we at least got to spend some time with her before.
When you guys, can I just say the Bocce's freak out? Now that I think about it, it didn't start at the airport. It started when she arrived. Because why did Bocce pull out this ticket? No, it actually started in the morning because she got on the wrong train. She was going the wrong direction in the morning too. No, Bocce, where is Bocce? Carol, did you forget in the morning she was going the wrong? Because I woke up to her messages.
She was getting on the trains, and they were like, "Guys, it's taking me the other direction."
Mind you, I'm knocked out. I'm snoring at this point. So Carol is dealing with Bocce, and I don't even know this is happening. So I wake up and I see the text messages of the panic. But at that time, Carol had already situated the Bocce situation. So she's already on her way back. And then Bocce gets to the hotel and we're looking at her ticket and it looks like she bought the wrong ticket. Because Carol and I are like, it costs $3. Bocce's like, I spent $37. So we're like, you got scammed.
And then she had time to get lost. Yeah, but we made it. We made it on time. Yeah. We just went for coffee a little late.
Yeah, which is the benefit of the hearing being in the afternoon. Like, I love that afternoon hearing. Because if it was in the morning chat, I don't think I'd have made it.
No, she was still not up by like 10.
I don't think I'd have made it. No, because Carol was a bad influence. That girl kept looking at the waiter and was like, another one. Another margarita, please. Can we get this to go? The waiter was like, no. Carol was like, what do you mean now? Oh my God. Somebody said, Elsie, you let Carol eat first? Oh yeah, because she had to go first. And I had a lot of time and we couldn't both be like mukbanging in front of you guys' face.
I guess we could have turned it off.
Yeah, no, but I mean, we were in a groove of things.
Bocce, hopefully you got used to the pen. And the little hand sanitizer.
Oh my God. The click, 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 click.
Oh yeah, the courtroom was like.
It was so funny. No, but if we go again, I think we should go because Carol got there earlier than me. My flight almost like got there way too late. We almost didn't make dinner. I mean, we would have because the restaurant we chose doesn't close like 2 a.m. But we got to dinner super late. I felt bad. And I kept texting Carol. She was like, I ate a candy bar. It's okay. And I'm like, actually, you could just go eat without me. It's fine. She's like, I'll wait. And I was like, girl, it's 11 p.m. No, but because my flight got delayed. And then when we landed, the train, what happened to me was the train literally stopped in the middle of, because I was going from JFK to the financial district and the train stopped around like, I don't remember where it stopped. Literally stopped halfway. And the conductor was there. That's like, oh, this is our last stop for the night. And everybody was like, huh? Even the locals were like, what are you talking about? He was like, yeah, this is the last stop. We can't go any further. And literally kicked all of us off the train. And I'm like, what do you mean we can go further? I'm looking, I have like 10 stops left. So I was like, I'm not about to lose my mind over this. And then the conductor that has told me, just Google where you're going. I'm like, you live here. Just tell me where to go to catch the next train. And I just was like, I can't keep doing this back and forth. And I hopped in an Uber. I came up for air and I hopped in an Uber. I was like, I can't do it. Yeah, but Carol and Elsie Take New York Part 2 will be better. Like with the Kardashians now. Elsie and Carol take NYC. And we can actually, if you guys want, instead of like a live where we blabber, we can like give you a vlog and post the video later. How about that?
That would be fun.
Yeah, because I have my DJI, my little pocket camera, and it can record pretty well. So I think that's what we should do. We should land a little earlier. That way we can do more. Because Carol got there early and went shopping and everything before I got there super late. And then we just checked out the next morning and left. So, oh, somebody said this was the first time. I had to go back and do the rewatch. This was my first time seeing what the airport security looks like inside the machine too. So I guess I gave you all a first time experience. You're welcome.
We got to do it with Bocce though this time.
Yes. So Bocce, you cannot take the red eye and come the morning off. I mean, you can, but you're just gonna have to hop on the live. I mean, on our vlog later. I'm gonna get Lauren to participate.
Well, yeah, I like Lauren.
Yeah, Lauren is so sweet. I'm gonna get her to participate in the shenanigans. So if you guys are up for it and you really want, we could give you an entire from at the airport.
We're ready. Oh,
Carol would be responsible for filming her POV when she's at her airport. But once we land in New York, I'm on duty. I'm going to have the camera from every angle. We can even try to land around the same time so we can baggage claim and everything. Well, we'll have a carry-on, so maybe no baggage claim.
Bocce said I probably would still come the day of.
That's what I said. She's just going to, see, she's going to do it. And then call us, talk about she's lost. No, but I think we will give you guys a legit vlog. I'm making the promise now. I'm making the promise to give you guys a legitimate vlog. If we do make it to Kara, we can probably take this down. Our presentation. We're gonna give you guys a vlog of everything. I forgot to tell you, ladies.
We still have some hearings coming up. All right.
Yeah.
There's no hearing set for the Genable stuff, right? So that's still coming up. Let's see. What is coming up. Let me check.
Woo! That is my alarm, guys. Don't panic. Not you.
Okay, so next week we have lively filing or fees. The week after that, but actually in court we have so there's the status conference. So status conference in the Joan v. Abel case. Last time it was very short for like the Wayfair one. That was before the oral arguments. I think it was like 30 minutes. That's the status conference. That's August 19th. That's the next thing in New York.
Yeah.
And then they still have to set the pretrial conference. It'll probably be after that date. And then the similar kind of process to all this. Let's see what Bocce says.
When we joked about doing it behind the scenes, I was like, oh yeah. Bocce was like, yeah, I won't be there. You will not find me there.
She's like, nope. I'm surprised we got her to do that video.
I know.
No, but it's really interesting. Where is Irma in the chat? Oh, hi, Irma.
Irma, hi. You guys, Irma is so sweet.
Yeah.
We went at the same time. Irma showed up with water and some snacks. We walked up and Irma was already sitting there. She's like, hi. I'm not even joking, you guys. I almost jumped out of my skin because nobody calls me Elsie except like, Carol. Bocce calls me Elsie.
Oh yeah, I was so freaked out. I was nervous to turn around.
I was like, wait, oh God, they found me. I said, oh, Blake sent the CIA. She sent, they're about to kidnap me.
Because they said clearly like Elsie.
I was like, Elsie, Carol. I was like, oh, what the?
Yeah.
And then when we came out of court, Jamie is somebody who watches us. She was outside. And that actually legitimately, I legit jumped because I was outside of court. I was like, oh, Blake got me. She sent the assassins. I thought Blake sent an assassin after me. Just like, Elsie. She legit jumped to hug me. And I was like, oh my God, hi. But I don't know who you are. And if it still freaks me out, I forget that people watch me and they know my name is Elsie. I feel like if she said Elsrich, I probably would have been fine. But
yeah, like, I heard Irma when you said Carol, and I was like,
Docket updates.
Yeah, but I guess I just expected to see people on the opposite side, and this time you sat in a different location.
Yeah, so. No, and I had never been there, so I didn't even know and there was a park, and I think that's what also freaked me out. There was a park right across, guys. There's a park right across the courthouse with people working out, people hanging out. So I was like, there's no way some random person in New York knows me enough by name to call me Elsie in broad daylight like this. I was freaked out. No, that's funny. No, but Irma was so sweet. She had water for us. She had these egg tart things. She was very, very sweet and nice. Wait, somebody's asking the drama between Teresa and Nag. You're gonna have to go on the page to get the deets. I don't know enough to educate you. I don't know enough to tussle. You're gonna have to go over there. There is enough information to get an understanding on both sides now, because Nag responded on her page now, so it's not a one-side POV. You can go get both. Hi Elsie, what are we doing? Oh, Kim, you just got here. We just read. Wait, sorry. No, I don't think that's Central Park. The park across the courthouse? No,
it's like a tiny little park.
It's like a tiny little park with like a few workout, not Central Park. No.
Guys, we kind of just like started talking about New York, but were reading the full settlement and just try the takeaways were the full settlement says it's done, right? There's nothing there that she can come and start a new lawsuit. It is done. It says that she had a pending motion, not lawsuit or a what is it called? A code that was outstanding. It just said motion. So it's really down to that motion, unless Lively finds a way to say that motion is related to this new lawsuit. But it's very clear. I've linked it on docketupdates.com. It is on the Megyn Kelly. They got an exclusive. Megyn Kelly got an exclusive. I did link her website, so you guys could read the full article on there. But it doesn't have an NDA, doesn't talk about that, and it doesn't talk about any money being exchanged one way or the other.
Yeah.
So, but I have it in there so you guys can check it out. But that's what we were going over. Bocce was with us at the beginning, during our lunch break, and then we just kind of deviated.
Somebody said I'm watching too much K-drama. Why? Because why? I don't know. Wait, what did I say to bring that on? I mean, I am, but why?
Okay.
What about filing in California? No, the judge, whatever decision the judge is making here is it. She can't go do anything in California.
Yeah, it just says like it's over. Like she can finish filing her motion pending, but that is it. It doesn't say she can do more than that. It just says after that it's done.
Are we going to NYC eventually, Kimberly? Eventually. We don't know when, but there is a New York trip somewhere in our future.
Because they still have to argue about fees, right? Mm-hmm. And so that's still outstanding. The judge said appropriate fees for the dismissal of the defamation. So
appropriate measure of fees, yeah.
Appropriate measure of fees. There we go. So, but we know Blake Lively's going to do Blake Lively things, so we'll see.
And for that, we thank her. She wants to keep acting crazy. We're going to meet her with crazy. We are right there with her.
So I shared it on here, the settlement, but if you guys want to check it out, it's on docketupdates.com. You guys can also pull up like Megyn Kelly exclusive on full settlement. It should come up right away. And that's pretty much it, guys. We're just waiting on anything else to happen and seeing if
it would tell you that this would give an indication as to how many millions. No. Not on the case. No. Whatever we find out in this fees hearing, whatever, is not gonna get. I mean, I guess if you're like a great mathematician and you know how to pull variables, maybe, but it's only gonna give us an indication on this claim, on this one claim, the amount of money they spent on this motion to dismiss and defending this 47.1 mess.
And remember, she has to separate that out from everything else. So it's only for the 1 out of 7 claims that Justin and the Wayfarer parties brought. And and out of that, the defamation, it was Leslie Sloan, Ryan Reynolds, and her. So they're going to have to parcel that out. It can't include everyone else. It just includes her.
Just her.
The NYT said that their fees for fighting the defamation claim was $186,000. This is the New York Times, guys.
Yeah.
For that one claim. And I don't think that her fees will be significant. Someone mentioned in a comment that in the Texas case, she's saying that her fees were $800,000. She's gonna have to prove it, right? She's gonna have to prove how she got to that number. There's no trust me, bro vibes from here on out.
Oh, that made me miss Ashley.
Ashley? Why?
Ashley Brianna Eve. No, in the beginning of this case, when we were waiting for evidence and we were waiting for things to come out, anything Blake Lively would do, she would be like, trust me, bro. Blake Lively wants you to trust her, bro. Believe her.
I mean, people did. We just have the more information, more context, more everything. So, I don't think it's going to be significant. It is only for that fee. I think it's probably going to be in the 100 to 200K. I don't know. I think at that point, if the judge says, yeah, $800,000 is reasonable, I'm going to start looking at him sideways.
We've been looking at him sideways. But Brian Friedman keeps be like, I think Judge Lyman is really smart and he knows what he's doing. And I'm like, yeah, you have to say that. I don't have to. He has one more chance to piss me off and I'm coming on my skin. I'm be like, Judge Lyman, we gave you all the benefit of the doubt and you're going to show your ass like this?
Yeah.
Allegedly, Judge. Don't take offense. Not yet.
Not yet.
If you play in our face at the hearing, take all the offense because I'm coming out and I'm talking all kinds of shit. And the good thing is we're thinking if there is the hearing for the fees and stuff, we won't have to be rushing back to court, back to the airport. So we're really going to get a chance to either stay outside the courthouse all day and talk crazy or go back at the hotel, sit down and talk crazy. So we will really have a chance to dissect and have like a proper conversation with whatever happens at trial. And if you guys know anybody in New York that can get me a press pass so I can bring my phone, that would be sweet. Because I saw people with their phones and their laptops. I've never been more jealous of a group of people. I'm not a jealous person. I don't have a jealous spirit. But seeing people with their phones and their laptops doing whatever they want at a court, I was like, ew. Look at them. They think they're better than the rest of us.
And they were.
They look like they were better than the rest of us, didn't they? They look like it too. They look like, oh, look at her with her A4 sheet and her pen, clicking pen. This was us, like little crackheads clicking the pen, trying to write. And they were all like, probably had their laptops dictating whatever they were hearing.
Well, so all we did was cover the full settlement, Kiara. There was the full settlement document that was signed by all the parties was released to quash this conversation that Lively has a right to sue them somewhere else.
Yeah.
And here it says the agreement just, we're not attorneys, but in reading it and extracting it in layman's terms, we concluded that there's just no way unless she does Blake Lively things and finds a way.
Which she shouldn't be able to.
Which she shouldn't be able to because I mean, it's really clear. She can't bring any other claim. They strictly carve out the motion, 47.1 motion, and anything tied to that. It doesn't say like they have the right to pursue a 47.1 lawsuit. Doesn't say that. It just says they will leave the pending motion open with Judge Lyman or otherwise, I think it says. So we'll see. But I think that's the end of it. So, and there's no monies exchanged. No NDA on that full settlement. Thanks, Patricia. Clickety, clack.
Oh, that's me. Oh, that's both of us.
Yeah, we were writing with the color pens.
Oh, yeah, in the car. I thought my typing with my nails on my keyboard was coming through.
All right. Well, thank you everyone for joining. We had a blast reviewing this with you.
Thank you guys. We appreciate you for coming. And now you guys have given us a real task of Elsrich, Bocce, Carol in the City. Produced by Wafer.
No.
You thought you were about to clip this? You're not going to get me. You thought you were going to get me, huh? I'm faster than that. They're about to say, oh my God, Wafer Studios, send them to New York, guys, please. Please, guys, please. It came out of our own check, came out of our own pocket. No, but if we do make our way, when we do make our way to New York, we will bring you guys. It won't be properly edited, properly produced because I don't have the time. But you will get all the angles, uncut version of everything.
And we'll put Drake music. We gotta go before Elsrich crashes out. That's the face of a crash out right there, guys.
Drake music
in the background.
Carol, just you know what? This is why you can't be friends with everybody because they start taking advantage of the situation. Because you should never be this comfortable with me on any level to say such things. And it looks like you're starting to get too comfortable around here. That's the vibe I'm getting. I've made you a little too comfortable to think you can say shit like this. And for that, I'm out. I'm not
And-
investing in this, whatever this is anymore.
Yeah,
I'm
you guys will go through TSA again.
I'm actually appalled. I'm appalled, guys. She knows she's threading. She knows she is on thin ice. She knows she's on thin ice.
There's very few things we disagree on. Drake is one of them.
Find your way to the exit. Wait, am I in your house? I am in your house. I'm finding my way to the exit.
Okay. All right, guys.
We could have ended this harmoniously. We could have ended this on a great goodbye. I'm so sorry for everybody else who had to sit through that. Oh, somebody said hello, lovelies. Oh, was this earlier? Oh, it was like an hour ago.
Nice.
I didn't see. Someone said, shut up, Flake. It takes you guys to bring us back together. See, I knew somebody would unite us eventually. But Carol will find a way to make me angry.
Right, guys. So
guys
we're going to tune in Monday when Blake has to file her fees.
We'll be here. And thanks to the replay crew. You guys are also amazing. We thank all of you. And leave your comments. Let us know what you think from Carol's ridiculousness with the Blake Drake obsession. You know what? That makes
We'll play bocce music. You know what? We'll just
that makes me think you might be an undercover Blake agent.
Girl, don't be starting rumors.
Like Drake, the only Blake Drake, Mike Godly, same Kool-Aid, same vicinity. Yeah, you starting to be suspicious, sister. Don't be suspicious. Don't be suspicious. You starting to be suspicious. Guys, we love you.
Bye.
We appreciate you.
Yeah.
Get out of here.
Bye, guys.
Bye. 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 Carol, you end this.